Am I personally liable for S Corp debts in bankruptcy? Have you ever wondered what happens to your personal finances if your S corporation faces bankruptcy? This is a common concern for many business owners. Let's break it down. Generally, shareholders of an S corporation are not personally responsible for the corporation's debts. The S corporation is its own legal entity. This means creditors usually can only go after the corporation's assets to settle business debts. So, if your S corporation files for bankruptcy, your personal assets are typically safe from business creditors. However, there are some exceptions to this rule that you should know about. One major exception is personal guarantees. If you, as a shareholder or officer, signed a personal guarantee for a loan or credit line, you could be held personally liable if the corporation defaults. Lenders often ask for these guarantees, especially from smaller or newer businesses. Another situation to consider is if you used your personal assets as collateral for business debts. If you pledged your home or car to secure a loan, those assets could be at risk in bankruptcy. There is also a legal concept called piercing the corporate veil. This happens when a court decides to hold shareholders personally liable because the corporate structure was misused. For example, if you mixed personal and business finances, used corporate funds for personal expenses, or did not properly capitalize the corporation, you could face personal liability. Tax obligations are another area where personal liability can arise. Shareholders might be personally responsible for certain tax liabilities related to the S corporation, including taxes on income generated before, during, and after bankruptcy proceedings. When an S corporation files for bankruptcy, it usually does so under Chapter 7 or Chapter 11. Chapter 7 involves liquidation, while Chapter 11 is for reorganization. The filing stops creditors from collecting debts temporarily. However, it does not automatically remove personal liability if you have guaranteed debts or if other exceptions apply. To protect yourself, consider these practical steps. Review any personal guarantees you have signed before filing for bankruptcy. Avoid transferring assets improperly before bankruptcy to prevent fraud allegations. Consulting with legal and tax professionals is also wise to understand how bankruptcy affects your personal finances and tax responsibilities. Timing can be important too. You may want to think about the timing of your bankruptcy filing and whether it could affect your S corporation status. While the S corporation structure generally protects shareholders from personal liability, you can still be held responsible if you have guaranteed debts, committed fraud, or failed to follow proper corporate formalities. Bankruptcy provides a legal framework for addressing the corporation's financial troubles, but it does not change these fundamental principles.